Okay, court does call the case. People versus Nathaniel Lucas.
Your Honor, we cannot discuss the injury and that's legal.
Assistant Public Defender Natalie Pate for Mr. Lucas, who is not present, Your Honor. He is in custody at St. Joe's Hospital.
And
So we need to go there.
Hey, I'd be down for a field trip.
Road trip.
In light of that, I did speak with Ms. Tanha briefly, and she did seem to indicate that people would be able to proceed today. Given that and that he is in the hospital, I would be asking for an adjournment of the preliminary exam.
Your Honor, that's accurate. People have
So what'd you say to the adjournment?
leave it to the court's discretion.
Okay. All right. Is there anticipated a time that he may be, or
Frankly, Your Honor, I don't know. What I do know is he was not in the hospital on Friday, but yesterday morning at 8:40 a.m. when I went to visit him, he was already in the hospital. But they could not tell me when he went or what his issue was.
Curious.
Because he left me a voicemail not in the hospital Friday afternoon at 2:30. So something happened.
So he was in the jail.
Yes. So something happened
Well
between
enough to
then.
call you on Friday.
Mhm.
And then at some point between Friday and
Yesterday at 8:40 a.m. Yeah, I don't know. For all I know, he broke a bone. He has an infection. I hope he's all right.
Will be clarified once we see the documentation.
well, glad I don't have to be part of it. All right, so here's what we're gonna do. I'll adjourn the preliminary examination.
Thank
I'll
you.
adjourn it to November 18th, 2025, 9 a.m. That will be before Judge Washington.
Your Honor.
Thank you, Your Honor. Excuse me.
Fine, continue. I should have done that for today. People talk to me on Friday and then I could just say I'm not here. Oh, no. Zary, don't call them. Is there a case up here? Just ignore her. Court does call the case. People versus James Hagan.
Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
And Assistant Public Defender Natalie Pate on behalf of Mr. Hagan, who stands to my right. Please state your name for the record, sir.
James Hagan. Thank you.
And Your Honor, please, for a preliminary exam that people are unable to proceed.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Jessica Hafner.
Rob Dowd, Prosecuting Attorney on behalf of the people.
Kyle Brill on behalf of Ms. Hafner. Just please state your name for the record.
Jessica Hafner.
Good morning, Your Honor. Today is the date and time set for preliminary exam. The people have tendered an offer whereby Ms. Hafner would plead no contest to child abuse fourth. We intend to take the people up on that offer. The court should be already in receipt of a sentencing judge waiver as well, and the plea form, as well as a copy of the police report and her assigned advice of rights form.
Plea form I have indicates that the defendant will be pleading no contest to the charge of child abuse fourth degree, the 1 year offense upon successful plea to that charge. Count one would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, that is correct.
That's correct, Judge. Count one is the child abuse.
May I have her sworn?
Raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Jessica Hafner.
Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of child abuse in the fourth degree. That's a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes.
Do you understand what it is? Pardon?
I'm standing mute, not saying guilty, not saying not guilty.
All right. A no contest plea means that you're not contesting this charge. You understand that?
Okay.
You
Yes, sir.
understand that, ma'am?
Yes, sir.
You understand also that what I would do, and I have reviewed the police report in this matter, and I would accept the facts in the police report as true to determine whether or not this crime was committed. You understand that?
Yes, Your Honor.
All right. You understand that for the purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You have any other questions regarding a no contest plea?
No, Your Honor.
So do you think you understand a no contest plea?
Yes, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability.
Ma'am, you do understand that you'll be sentenced before Judge Washington in 14B District Court, although I'm taking your plea.
Yes, Your Honor.
All right. So ma'am, to the charge of child abuse, 4th degree, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on there.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to do?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-96798. Any objection to the court having reviewed that report?
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the offense. Ma'am, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would first of all not be entitled to any evaluation or recommendation. The court would no longer be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge.
Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
You have and it would.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
December 11th at 10 a.m.
December 11th, 2025, 10 a.m. before Judge Washington.
Thank you, Judge.
There is a motion to modify bond.
Yes, Judge, it should be a stipulated order.
Stipulated order.
Yes,
This is what we discussed the last time.
yes, Judge, and it reflects the language, including the case number from the neglect abuse docket.
Very good. Bond will continue with that modification.
Thank you, Judge.
Court does call the case. People versus Brent. Is it Hackbar?
Good morning, I'm Marie Penhouse.
Morning, Your Honor. Good morning, Your Honor. Dan Garrett on behalf of Mr. Hackbarth.
Brent Hackbarth.
Your Honor, we're asking, I think, maybe it'd be a joint request for adjournment. If not, it could be ours. There's a substantial amount of discovery that we requested that was just coming through this morning. I need to review that and go over that with my client. I don't know if Judge Washington's next exam date, Your Honor.
Why, you don't want me?
I want you.
He
Yes.
specifically asked for Judge Washington.
He did?
There's reasons for that, Your Honor.
Wow. Wow, really? I'm hurt.
No.
I'm hurt. No, you know how sensitive I am. No, I'm sensitive. I'm pouting.
Okay, bye.
All right. She did? She set aside time?
Yeah.
And they're messing it up? Your is messing it up. All right. Her next date, I understand that Judge Washington has some involvement, has done this, so I don't have a problem with it, although still hurt. Her next date is November 18th.
Oh, we're going to make that work, Your Honor. Thank you.
Sure. You can do it at Costco's. No, I'm kidding. You know I'm never gonna let that.
Apparently not.
Ever
Yep.
let that go. Will that work for you? I don't know what. Excuse me. What's her date after that?
So December 9th would be the next date.
Let's just keep it the 18th, Your Honor. I know she normally does a little bit later in the morning,
Does that
so
work for the people? All right. Preliminary examination will be adjourned November 18th, 2025, 9 a.m. before Judge Washington. Bond will continue.
thank you, Your Honor.
Thank you. Court does call the case. People versus BJ. Is it Pudell?
Good morning, Your Honor. Ken has supposed to be intruding that.
Morning again, Your Honor. Dan Garrett on behalf of Mr. Podell, stepping forward. State your name, would you? Please. State your name. BJ Podell.
Thank you.
Your Honor, this is the date and time scheduled for preliminary examination. However, people are unable to proceed with the felony counts, like counts 1 and 2. We'd ask for a remand to district court on count 3, malicious destruction of personal property, 200 or more, but less than 1,000. As well, this would be to add count 4, aggravated assault under 0H1A. It's a 1-year misdemeanor and or $1,000 fine.
I'll need a new complaint
Yes, sir.
filed. That's ag assault. Can you give me that pack code again, please?
Yes, Your Honor, it's MCL 750-818.
Thank you. All right. And as to the added count for your client waives any reading or presentation.
He does, Your Honor. Thank you.
And he stands.
He does.
All right. Court will continue to not guilty plea as to count 3 and enter plea of not guilty to count 4.
And then there would be a formal motion to dismiss counts 1 and 2 as the people are unable to proceed.
Counts 1 and 2 are dismissed. Set this matter for pretrial.
November 19th at 9 a.m.
That work for?
That's here.
Yes.
Yes. Perfect.
November 19th, 2025, 9 a.m. That is before me.
Thank you, Your Honor.
Bond will continue with its conditions.
Thank you very much, Your Honor.
Court does call the case People versus Jeffrey McCullough.
Over what assistant prosecuting attorney.
Good morning, Judge. Christopher Quinn, appearing on behalf of Mr. McCullough, who's present.
Jeff McCullough, Your Honor.
Thank you.
As the date and time set for preliminary examination, at this time people are unable to proceed.
For dismissal, Judge.
People being unable to proceed, this case is dismissed. Suspended motion that is without prejudice.
That's it.
Thank you, Your Honor.
Thank you. Court does call the case of Strong Future Homes versus Chanel McFarland.
A man pleads guilty to stealing a backpack worth less than $200. Instead of anger, the judge shows mercy, dropping 2 charges and telling him, "You've got a good heart. Just don't come back." A powerful moment of real justice and redemption.
Morning, Your Honor. Tish Lee on behalf of Ms. Chanel McFarland.
Good morning, Your Honor. Parissa Gazari appearing on behalf of plaintiff.
Good morning. I have before me a conditional order of dismissal.
Yes, yes, Your Honor.
For every reason, I'm satisfied certainly with that. Both sides being represented by counsel. I don't need to make further inquiry. This case is conditionally dismissed and I signed your order.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Edward Harris.
Trevor Mabel for the people.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward Harris.
Okay, can you hear me, Mr. Harris?
Yes, I can, Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. Upon, that's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be to count 4.
And then there would be a formal motion to dismiss counts 1 and 2 as the people are unable to proceed.
Counts 1 and 2 are dismissed. Set this matter for pretrial.
November 19th at 9 a.m.
That work for?
That's here.
Yes.
Yes, perfect.
November 19th, 2025, 9 a.m. That is before me.
Thank you, Your Honor.
Bond will continue with its conditions.
Thank you very much, Your Honor.
Court does call the case People versus Jeffrey McCullough.
Over what assistant prosecuting attorney.
Good morning, Judge. Christopher Quinn, appearing on behalf of Mr. McCullough, who's present.
Jeff McCullough, Your Honor.
Thank you.
As the date and time set for preliminary examination, at this time people are unable to proceed.
For dismissal, Judge.
People being unable to proceed, this case is dismissed. The defendant's motion, that is without prejudice. That's it.
Thank you, Your Honor.
Thank you. Court does call the case of Strong Future Homes versus Chanel McFarland.
Morning, Your Honor. Tish Lee on behalf of Ms. Chanel McFarland.
Good morning, Your Honor. Parissa Gazari appearing on behalf of plaintiff.
Good morning. I have before me a conditional order of dismissal.
Yes, Your Honor.
Court never read, I'm satisfied certainly with that, both sides being represented by counsel. I don't need to make further inquiry. This case is conditionally dismissed and I signed your order.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Edward Harris.
Trevor Mayville for the people.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward Harris.
He admits his mistake, a stolen backpack, $200 or less. The judge listens, understands, and offers respect and a second chance. You've been a joy, Mr. Harris. Don't come back here. One sentence that says everything about grace and justice.
Okay, can you hear me, Mr. Harris?
Yes, I can, Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. Upon, that's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay restitution in a total amount of $130 without a restitution hearing relating to the victim of Natalia Lovo. And that's specifically as to count 1, but he's agreeing to pay that amount. There's also the prosecutor and defendant are agreeing to a sentence agreement of 93 days of credit for 42 he served. There's a note that the defendant is incarcerated at the Washington County Jail as a result of being sentenced on other cases with an estimated release date at this time of March 3rd, 2026. That's the court's full understanding of the.
That is our understanding as well.
That's accurate. All right. The one thing I will do on the form without objection is I will check the sentencing judge waiver box. So this is not my case.
Without objection.
All right.
Thank you, Your Honor.
Thank you. All right, you ready?
He's executing the
I thought he was writing warrants.
device of rights.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name. State your name.
Edward Harris.
All right, Mr. Harris, it is this court's understanding that you are going to be pleading guilty to the charge of larceny less than $200. Is that right?
Yes.
That's a misdemeanor punishable by up to 92 days in jail, $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be the sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Right.
Okay, you signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
All right. On the date of May 3rd, 2025, at the location of 530 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan, what did you do that makes you think that you're guilty?
What was it I did over there?
Larceny.
Oh, I had committed larceny out of a building.
Okay. So did you take something that wasn't yours?
Yes.
What'd you take?
What was it? Backpack.
You took a whole backpack?
Yes.
Okay. And that backpack wasn't yours?
No.
And the owner of that backpack didn't give you permission to take it?
No.
At the time, you wanted to keep that backpack permanently in some way. Is that correct?
Yes.
Okay. Okay? Okay. All right. Sir, I do have to let you know that if I accept your plea, between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation or evaluation. You would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other actions which have led to this plea?
No, Your Honor.
Would it, have I complied with the court rule, and would it be proper to accept this?
I believe so, Your Honor, yes.
Yes, Your Honor.
Court, well, you okay?
Yeah, this one.
Okay. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 21st at 8:30 a.m.
November 21st, 2025, 8:30. That's before Judge Perry. All right, Mr. Harris, is this the last case you have before me?
Yes, it is.
Is it?
Yes.
Well, great. I wish you, Mr. Harris, you have been an absolute joy. All right.
Thank you.
Always very respectful in terms of the way that you approached, and you got a good heart.
Thank you.
Okay. Just don't take any backpacks.
I won't.
You won't do that anymore?
No.
All right, but I wish you all of the best since it's the last time I'll see you.
Oh.
I better be the last time. Don't do anything else to come back.
It will be.
All right. You take care of yourself.
All righty. Thank you, Your Honor.
And we'll continue.
Thank you.
Now we enter the cross-examination phase. And this is where self-represented defendants often sink or swim. He starts chasing probable cause, legal definitions, and hypotheticals. Question for you. Do you think he's helping his case or hurting it?